My name is Danielle Lackey. I'm the Executive Director of ClientEarth Americas. Many of you are close friends and supporters of ClientEarth, and thank you so much for your partnership. For those of you who are less familiar, let me share a bit about our work in the Americas. We all know that for decades, corporations have been harming people and our planet in ways that environmental law hasn't been sufficiently able to stop. And we know that in this country, the health of our planet is now caught up in the political crosshairs. We at ClientEarth Americas come at this problem from a completely new lens, from the neutrality of business law. We fight on behalf of the planet by bringing precedent-setting business cases that can change environmental systems. In other words, we take the fight to the corporation's own field. We are only able to do this thanks to the support of people like you. So thank you. Today is an opportunity to share some key wins from 2025 with a bit of a preview into areas that are going to heat up in 2026. And to do this, I'm joined by those leading the charge, three of the amazing attorneys on our team, who I will introduce in a moment. Before we get started, a few housekeeping points. If you have any questions, post them in the Q&A tab at the bottom of your screen at any time during the session. We will do our best to answer as many as we can. We'll take questions at the end. If you encounter any technical issues, please use the chat function and a member of our team will assist you. This session is recorded. So now to dive in. We have three expert attorneys with us today: Setareh Homayoni, Hana Heineken, and Kimberly Blake. First, to Setareh. Setareh is one of the attorneys working on our Zombie Wells case. She is a former big law, securities, and complex commercial litigator who now holds oil and gas companies accountable for their roles in causing the climate crisis. Setareh, thank you so much for joining us. Let me make sure that she is in the screen. Here we go. Hi, Setareh. So Setareh, could you tell us about the major highlights from this year in our Zombie Wells case?
Sure, Danielle. Thank you so much. I am so delighted and grateful to be here today. So the first highlight that happened in our Zombie Wells case was earlier this year, early in January. And it was approximately 1 week after the Pacific Palisades fires, which was a devastating time here for our community. The court denied the defendant's motion to dismiss in their entirety. And I'll come back to what that means in just a minute. But first, I just wanted to give a quick overview of what the case is about for those who might not have heard of it before. So our plaintiffs are landowners in Colorado that have abandoned oil and gas wells and other related equipment on their land. The reason that has happened is unfortunately a common fact pattern that we see across the US, where big oil companies like Chevron and Exxon buy the rights to drill that land. They do so, they drill it. They take much of the profit out, and then they pass the wells down to a smaller operator along with the cleanup liabilities that go with that well. And this happens for multiple transactions where the well continues to be passed down. In our case, it was eventually passed down to a company that was so underfunded that was not able to take on the cleanup liabilities and declared bankruptcy. That company was called Painted Pegasus Petroleum, so P3 we call it. And the company before it was HRM. And we are suing those defendants on behalf of all landowners that have these abandoned oil wells on their property. This is huge because there are approximately 2 million oil and gas wells across the US that are what we call orphaned or zombie wells that are just left polluting the land, the air, the water, because these oil companies took the profit, they extracted all that they could, and then they didn't want to clean up after themselves. And so the significance of the case ruling that our complaint was sufficient in denying the defendant's motion to dismiss was that the court said we have stated enough on the face of our complaint to be entitled to a relief. if the court assumes that our facts are true. It's the first stage of scrutiny that every case goes through in the US, and we passed that. The court's decision was particularly noteworthy in affirming one of the allegations that implicates potential liability under what's called fraudulent transfer law, because the court explicitly recognized that the landowners that are affected by these abandoned wells on their property can be considered creditors based on the company's future obligations to plug the wells on their property. We also allege some other causes of actions like trespass and unjust enrichment, which means that the defendants were unjustly enriched. They unjustly received money by doing these acts and leaving these polluting equipment and wells on the plaintiff's properties. This case builds on a similar ruling. This order of the court builds on a similar ruling in another lawsuit, only one other lawsuit that has ever used this fraudulent transfer theory to attack these abandoned wells. That was in West Virginia. The case was called McAvoy versus Diversified Energy. And so this ruling strengthens the legal foundation for challenging this industry practice of transferring the cleanup liabilities to undercapitalized companies that then later declare bankruptcy or they dissolve. So now having two federal courts validate this legal approach provides a great potential pathway for others to seek to hold fossil fuel companies accountable for their cleanup obligations through this fraudulent transfer law.
Thank you, Setareh. It's really momentous. And after this landmark ruling in the early part of the year, I know you had another important decision in the case just weeks ago. Can you tell us about that?
Sure. So that important decision was the court's granting of our class certification, which happened on October 17. So we represent three specific plaintiffs. Those are the representative plaintiffs. But like I mentioned, they're bringing this lawsuit on behalf of a whole class of landowners in Colorado, specifically 2 counties in Colorado that have all of these oil and gas wells on their properties. There's approximately 100 landowners that are affected by this. So now that the court has certified the class, it means that the whole class is pursuing these claims for the wells that have been abandoned on their property. And on October 17, when the court certified this, we essentially were able to prove that we met what are the requirements of class certification. Some of those requirements are things like numerosity, that we have enough class members in our class. Other ones are more substantive, that we had to do a ton of research and develop a lot of arguments around to prove to the court why our class deserves to go forward. And for example, we had to show that the issues were common across the whole class, and that the plaintiff's claims were typical. They were just like the claims of the rest of the class, or that individual issues did not overcome the major common issues that binded the class. We had to prove that we were adequate counsel and that our plaintiffs were adequate plaintiffs, that they had no conflicts. So we were able to prove all that, and the court ruled in our favor in a very great order. This ruling now doesn't decide the case, but it does change the scales drastically. So now, instead of the oil company facing a suit from just a few individuals, it's a unified lawsuit representing all the landowners. And the factual issues will be considered together by the court for the entire class. This also lays important groundwork for future accountability. By recognizing that these claims can be tried together, the court has acknowledged a pathway for others to bring similar cases against companies that abandon their wells and walk away from the cleanup costs. And they can do so as a class action instead of individual cases, which is much more feasible because these cases are so expensive and so resource intensive. And so this decision makes it easier to tackle this problem on a much larger scale. And of course, as we expected, given the conduct we've seen by HRM of applying all of their resources to delay the case and attempt to wear us down, they, HRM, sought permission from the higher court, in our case, it's the 10th Circuit Court of Appeals, to appeal this decision. And now this type of appeal is not automatic because it's in the middle of the case. It's called an interlocutory appeal. So it requires a permission before they're even allowed to appeal the case. That type of permission is rarely granted, but right now that's the stage we're at. We're waiting for the Court of Appeals to decide whether to grant permission or not. We're hopeful that the Court of Appeal will do the right thing and allow the lawsuit to proceed in a timely way. So in sum, we're very delighted that the district court, has sided with our plaintiffs on two major milestones just this year. And these decisions created clear pathways for others to bring similar cases against fossil fuel companies for abandoning these zombie wells, causing so much pollution, exploiting the planet, just for the sake of their own profit and not caring about the consequences to human beings and the planet. So this is a huge step in making it easier to tackle this problem on a much larger scale. Thank you so much, Danielle. Thank you so much to our supporters for this opportunity to be here to talk with you all, and for all the different ways that you all are supporting us.
Thank you so much, Setareh. We are now going to get some insights from Hana Heineken. Hana specializes in corporate and financial laws with a focus on climate change. She also supports our global work to accelerate the energy transition in Asia towards renewables, focusing on the role of Japanese companies in particular. Hana, what can you tell our audience about the work you do to hold multinational corporations accountable?
Thank you, Danielle, and hi, everyone. I am so delighted to be here with you all. And yeah, I just wanted to start with a little bit of introduction about myself and my background and how it relates to the work that I do. I was actually born and raised in Japan. And so I've always embraced my kind of bicultural and bilingual background, including in my professional work, and it's really enabled me to work seamlessly across borders and with global partners, and I think that's particularly valuable in this work. Given my Japanese expertise, one of the key issues we focused on is the rapid and destructive development of liquefied natural gas, so LNG export terminals along the Gulf Coast, namely in Louisiana and Texas. And then we're also seeing that kind of development now in the Gulf of California, in Mexico. And the US is, the largest LNG exporter in the world. Japan is the largest LNG importer in the world. And Japanese companies are among the largest financiers of this development that we're seeing now in the Gulf Coast and then in other places. So, why is this concerning, right? First off, natural gas, that's a very misleading term. We should be calling it methane gas because most of it is methane, which is 80 times more potent in terms of climate warming than carbon dioxide. Most natural gas is converted to LNG, which makes it easier to transport. And a lot of industry will say, well, LNG is cleaner, is one of the cleanest forms of fossil fuels. But in fact, they don't count the full life cycle emissions associated with LNG. They're mostly not counting what's happening upstream, right? When they're extracting shale gas. And studies have shown that if you consider the whole impact, it's actually 1/3 more climate harming than coal. And it's not just the environmental effects. A lot of communities, particularly those who live in the coastline in Louisiana and Texas, are increasingly becoming sacrifice zones for this kind of development, where their ecosystem is being affected, where they're being subject to pollution, and even, some explosions associated with these facilities. So we're utilizing our background in corporate and financial laws to support the Gulf Coast communities and others in the front lines to fight back against this unprecedented fossil fuel expansion, where we're seeing about 25 proposed new LNG export terminals. And this would just create even more fossil fuel dependency, at a time when renewables are clearly available as an alternative.
Wow, thank you, Hana. Can you tell us about a project that you are really excited about where our supporters could get involved?
Yeah, absolutely. Happy to. And yeah, so I'm going to talk about this picture. What's going on, right? Over the past year, we've been actively working to stop the construction of a massive LNG export terminal in Mexico in the Gulf of California, called Saguaro Energia LNG. And this project, if built, would be transporting gas from the Permian Basin in Texas through this, Gulf of California to import LNG import terminals in Asia. And this area, Gulf of California, it's called the aquarium of the world. I mean, it is, imagine thousands of blue whales, fin whales, dolphins freely swimming in these waters. It is one of the 3 key breeding grounds for whales globally, because it's considered safe and clean, right? And the Gulf is home to 1/3 of all marine mammal species on the planet. And that's why it's been designated as a World Heritage Site. So this LNG project would threaten this amazing ecosystem. It would increase the marine traffic. And it would create lots of pollution. And this is why groups like the International Union for Conservation of Nature, IUCN, recently warned against this LNG development. So what are we doing about it? First, I do really want to uplift the amazing work that our partners in Mexico are doing, in collaboration with the communities. They've collectively filed about 10 lawsuits in Mexico to challenge the permitting of this enormous LNG export facility. And they've stopped the development. It's what's called an injunction. And so it's stopped in its tracks. ClientEarth, and in collaboration with Natural Resources Defense Council, have been jointly pressuring key financial institutions that are backing this project to get them to reconsider their involvement in these projects, given the substantial risks. These are household names like JP Morgan Chase. It is also Mitsubishi UFJ Financial Group, which is the largest bank in Japan. And we've been writing legal letters, we've been holding advocacy meetings, we've been holding film screenings and talks, and now we're pushing their investors, given it from our perspective, the banks aren't being truthful about the impacts of their financing activities. So here's where you can really support us. We're going to put a link in the chat where you can join us in telling JP Morgan Chase to stop backing these fossil fuel expansion projects that threaten our climate future and endangers these blue whales and other vulnerable marine life in the Gulf of California. So please sign the petition. We're hoping to deliver this by the end of the year. Thank you.
Thank you so much, Hana, and thank you to anyone who adds their name alongside ours in our efforts to hold JP Morgan Chase and others accountable and fight for the protection of this essential marine habitat. Next, we have Kimberly Blake. Kimberly is an international dispute resolution attorney. At ClientEarth, she focuses on integrating climate-related financial risks into private retirement fund management. We're going to get into what that means. Ensuring that fiduciaries account for how climate change impacts long-term financial stability. She also supports ClientEarth's Latin America and Caribbean initiatives related to climate justice, agricultural supply chains, and biodiversity. Kimberly, why is ClientEarth thinking about legal interventions related to 401k plans?
Thank you, Danielle, and thank you to everyone for being here. This is so exciting to do just an end of year recap and share some of the things that we've been thinking about with you all. Yes, indeed. ClientEarth is fascinated by the potential for legal interventions in the 401k space. You may ask why. So the private retirement savings market in the US is just one of the biggest pools of capital in the world, right? A lot of folks have 401k plans and sort of private retirement or pensions. There's not so much of a government scheme that most people are invested in for their retirement, right? So there's this entire pool of money that's to set up retirement security for everyday Americans. As of March of this year, there is $12 trillion invested in defined contribution plans. So that's 401k plans, 403b plans, and the like. So essentially, the fiduciaries, right, the people who manage these plans and these financial assets have a huge amount of influence over how capital is allocated across the economy, right? And again, 401k plans, these are people's life savings. So we're entrusting our employers to give us investment options, to manage how our money is being invested, to watch our savings grow. So it's just incredibly important. And this is like an issue that touches on so many people. So for us, looking at this space as one where we want to make sure that climate risk and climate change considerations are considered in how capital is allocated, is a way for us to influence how trillions of dollars are sort of being moved through these tax advantaged accounts. In doing so, and in making sure that fiduciaries have a responsibility to consider climate-related risk as financial risk, we are able to hopefully help shift capital from climate and nature degrading activities and towards more sustainable and resilient investments. And as an added bonus, we also get to help sort of safeguard worker savings from foreseeable long-term harm.
That's great. Can you share with us what employers and asset managers are actually required to do under the law when it comes to managing our retirement assets?
Absolutely. So given like the huge number that I said earlier of the trillions of dollars that are invested in these accounts, Congress has made a point to have a really clear regulations about what employers need to do and what sort of the retirement plans committee or whoever is responsible for managing these accounts, what they need to do. There's a federal statute. It's known as ERISA, the Employee Retirement Income Securities Act, right? Security, I think, is the key word. It's an act of Congress that establishes sort of really robust fiduciary duties for the folks that are managing these plans to make sure that the security of people's retirement savings is always at the forefront. So there's two primary duties and responsibilities. The first is the duty of prudence, which requires fiduciaries to act with the care, diligence, and knowledge of a similarly situated fiduciary, right? So again, we're entrusting our money to our employers. They need to manage that money with sort of excellence, sophisticated asset management and financial risk management practices. That is federal law. The second core duty is the duty of loyalty, which means that everything that fiduciaries do in support of these plans must be directed towards the best interests of the plan participants, right? Which means we can't invest in funds because someone's friend is on the board of whatever company, right? We constantly need to think about what is going to be best for retirement savers and their long-term financial stability and their long-term retirement security.
Makes sense. So you've been talking about climate risk, and we talk about that a lot as a financial risk. What are the risks to businesses and to people's investments that climate change introduces?
Thanks, Danielle. I think we're all able to understand sort of the damage and impacts that climate chaos causes, right? We can imagine, as Setareh raised earlier, sort of the Pacific Palisades fire and the damage that was done to property, right? What's happening with insurance companies? Are we able to cover those losses? These are real financial losses. So thinking about climate risk in the financial space is really sort of trying to quantify the financial impact of climate change. It usually can be broken down into two broad categories. One is physical risk. So that's kind of what I described: damage from severe storms, from fires, damage to infrastructure, the financial cost of that, right? And then on the other hand, we also have transition risk, which is as the world is transitioning to a lower carbon economy, certain types of businesses are likely going to be less profitable unless they're able to pivot to sort of more sustainable ventures, right? So a great example of a company that would be exposed to transition risk would be like a coal utility, right? There's a bunch of sort of law and regulation about phasing out coal power plants. A company that is only invested and only working in coal power plants is obviously going to be subject to some financial losses when, as the energy transition continues. So the financial sector is very good at like adapting to emerging risks and managing risks. I always give the example of like pandemic risk, right? Before the COVID-19 pandemic, there weren't so many sort of rules in place or disclosures around like, how are we going to account for the risk of a pandemic? Okay, well, then it happened. Now the financial sector really has evolved and adapted to have tools for financial professionals to like consider pandemic risk in the same way that it's considering climate related risk. These sort of risk management tools are ones that should be used by retirement plan fiduciaries, right? Alongside that duty of prudence, which is to act as a similarly situated fiduciary with sophistication and sort of being on par with everyone else in the financial marketplace.
Great. So I'm curious to get your thoughts in the midst of the politicized attacks against investors considering ESG or environmental, social, and governance issues. What does that mean for considering climate risk?
Yes. It's really almost like a somber question, Danielle, because I think the political backlash against ESG, right, which is like environmental, social, governance issues, has just gotten wrapped up in a lot of sort of like the cultural war going on, unfortunately, in this country, right? We've seen companies rolling back DEI policies, even though we know like there are benefits to having a diverse group of people thinking about issues. Like there are studies on it. We know that that's actually positive for companies. We know that that helps companies with their bottom line, right? The same thing is true of sort of environmental considerations and climate considerations, right? So part of what we're trying to do with our intervention in this space is to really kind of separate financial risk from the sort of cultural warfare going on. And this is why it's just so cool that there's so many different NGOs and nonprofits that work on different issues. We are really going to just be focused on the financial impacts of climate risk at ClientEarth. It's sort of part of how we're able to be a little bit neutral in how we make change, right? So for us, we're not asking really for new laws to be on the books. We're not having a conversation about values, morals, how people feel about the culture wars. This is very clear. Climate change has real financial impacts. These impacts affect stock market investments. They affect real property investments. They have implications across the financial system. For fiduciaries of 401k plans are required to consider all material financial risks as they go about managing these plans, period. Full stop. That's what ERISA says. And that is what courts have been saying for centuries, or not for centuries, but for decades, right? Since the 70s when ERISA came onto the books. So for us, we just want a court to be able to recognize, like, yes, climate risk is indeed one of those financial risks. Like any other financial risk, credit risk, liquidity risk, that retirement plan fiduciaries have always been required to consider. And in doing so, we're hoping to give retirement plan fiduciaries sort of license to go ahead and really protect folks' retirement security. We know long-term security requires monitoring and consideration of climate-related risk. We don't want sort of the political headwinds to make it so fiduciaries feel trapped and that they can't actually be looking out for the best interests of the plan participants. So we're just looking for a court to affirm what federal law has long been stated. And in doing so, we're hoping to kind of, again, get sort of the climate risk discussion away from some of the cultural wars. And as we do that, right, we're always going to be supporting other NGOs that are focused on the sort of DEI issues and other social issues. Like that's very, very important for us. But I think we need to disaggregate sort of like ESG and it's come to be meaning like politically. So that's, I think, how we're moving in that space and the effect that we can have that hopefully will be positive for, like, again, everyday Americans who've been working hard to put their money away and save for retirement.
Yeah, no, thank you. And for those joining us today, this is something we've been giving a lot of thought and deep work to, and we'll have more to share concretely in the coming months. So thank you all for sharing your insights today. It is truly my pleasure and my thrill to work alongside you and the other talented team members at ClientEarth Americas. So I want to invite the three of you back up onto the screen while we turn to Q&A. And thanks to everyone for joining us, and thank you for submitting your questions in the Q&A. We have some good ones waiting here, so let me jump right in. The first, there's a couple that relate to the zombie wells work. They're somewhat similar, so I will connect them. If you prevail, can this ruling on a class action against zombie wells be a precedent in future suits against corporations? And sort of relatedly, since zombie wells are a national issue, has ClientEarth looked into addressing this problem in states outside of Colorado to sort of build the groundswell of legal precedent? Setareh.
Yes, thank you, Danielle. Yes, to both of those questions. This can absolutely be used as precedent in other cases. So one of the great things about American law is that we don't just have statutory laws, we have case law. So every time a judge issues a ruling, a written ruling, it becomes precedent that other cases can use if they're analogous. They can they can cite that case to make their arguments. So this is great because we have forged a deeper pathway to making this a way to hold oil and gas companies accountable for their role in the climate crisis. And the second question, yes, we are looking at other states. Some of those states are California, and we hope to be able to launch cases soon, likely next year on those.
Thank you. Yeah, we have a lot of really exciting zombie wells work going on in the background, all about to culminate with some cases and some other things in the coming weeks and months. So stay tuned. Another question here for Kimberly, actually. So it's a question asking about our views on the outcome of this year's COP in Belém, Brazil. Since you just returned from COP on Sunday, despite looking so fresh and energetic after your long travel, can you share your observations?
Yes, thank you. I really appreciate the question. Yes, I have been reflecting so much on my experience at COP 30, which was held in Belém do Pará in Brazil. Belém is a city it's a port city where the Amazon River empties out into the Atlantic Ocean. So it truly has been known for centuries as the mouth of the Amazon. It is a city that is incredibly dynamic, like many Brazilian cities. You have Portuguese influence, indigenous influence, African descendant influence. It's just such a melting pot. And then, the streets of the city are literally lined with mango trees. There were just mangoes falling out of the sky everywhere you walked. So I think that environment brought out sort of all of the issues that really matter when we're thinking about how we can mobilize as an international community for climate action, right? So I think a lot of the feedback from sort of the more formal spaces of COP, like the Blue Zone is what it's called, where negotiations are held and countries are working on sort of a deal, an agreement, what can we all agree to take the next step towards our obligations under the treaty. The outcome of that space, I think people were disappointed. We were in a place in the Amazon. I think folks wanted to see a little bit more action on deforestation, for example. Folks wanted to see a little bit more action on a lower carbon future, pulling back from fossil fuels. Unfortunately, the documents produced in the formalized spaces didn't get us there. But I think really, and I think Brazil holding the COP presidency did this really well. This was actually a COP about folks getting together and again, to analyze all of the issues, right? Because if we're thinking about climate action, it goes beyond fossil fuels, right? We need to think about who's most affected by real climate chaos that is happening now. And there are frontline communities that have been going out of their way for centuries, literally with specialized knowledge on protecting forests, on protecting livelihoods that are more regenerative and sustainable. And I think a lot of those folks often feel that they're not welcome and haven't been invited into the formal negotiation spaces. So in doing the COP in Brazil, and the Brazilian government had housing available for indigenous leaders, people were there and they were present in Belém. So many amazing conversations and connections were made with civil society. And again, sort of centering people who weren't in the Blue Zone and haven't been invited to the Blue Zone. So for me, I felt like COP was an amazing success. For our America's works, certainly. We had great sort of feedback from our partners, great panels, relationship building, learning about where ClientEarth, America's attorneys who are expert litigators in U.S. federal court, how can we bring that knowledge and expertise to support all of the excellent work that's going on the ground by other grassroots organizations, both activist organizations and also legal organizations. And I think moving forward from this COP, like the idea of a just transition is just one that is now embedded in the framework for moving forward. Although it was not necessarily written in those documents, everyone who was there and who experienced the essence of being in that place and having conversations that you were unable to have anywhere else, it's like, we know we need to have communities at the center of this. We know we need to think about adaptation. We know we need to think about harm repair, and we need to not be shy in really calling for like a future that is not about extraction and oppression, but it's about how we can work together and like for sustainable, again, regenerative practices that like protect people and planet and animals, you know? That was really there, and it came across like so strongly in COP. So I was absolutely thrilled to be there, and I cannot wait to keep moving forward with, again, like the justice orientation in mind as we tackle really complicated federal law and statutes and bankruptcy and all kind of things. Like the heart of why we're doing this, I think COP just reminded us all of that.
It's a really beautiful perspective and reminder, and thank you, because I don't think that the coverage of COP gets at that more intangible connectivity point. So that's really, really beautiful to hear. Okay, we have another one for Setareh and then one for Hana. So Setareh, one of the questions, there are actually two that sort of relate, asking on zombie wells and asset retirement obligations, how can we know if the industry is aware of and concerned about these cases as an industry-wide issue rather than something affecting a couple or several companies? And I think this relates to this other question around challenges we've faced in the case. What I'll say is, opposing counsel and the defendants are litigating this case like, sort of a standard, maybe defense style corporate law firm, but in the context of a bet the company case. You can observe it in the way that this is being litigated, that they are taking this very seriously, both for themselves and recognizing the implications. Or at least that's what seems to come through. So Setareh, maybe you can share a little bit more of the color around what that looks like in the trenches of litigating the case.
Yes, absolutely. I agree with that. Thank you, Danielle, for that great question. The industry, it seems very much concerned about this. It's like I said, it's such a common practice, and they don't want their practices to be challenged so they can keep profiting at other people's and the planet's expense. And so this lawsuit has attracted attention from so many different people and attorneys across the state. And because they're throwing in so much of their resources, we know that, like I said, they're concerned. We've had to battle to keep the case moving forward efficiently. They're clearly, the defendants are trying to delay as long as possible. And they have shown that they are relentless in doing that. But the court has been siding with us and letting us proceed forward. So we've had to do multiple hearings in front of the court to try and get the documents that we've requested from the defendants in order to gather our evidence. We've had to fight battles about the way that the case will proceed because they wanted to basically dissect the case and have it be moving in piecemeal ways, which would significantly delay the case. We won that battle too. And so yeah, this is very, very concerning for them. We know that from these behaviors that it's grabbed their attention and that they don't want to be held accountable for this type of practice. Did I answer the question?
Yeah, and I will just say, it's we are a small team, small and mighty, and it's amazing to see the way that the folks working on this Colorado case have just dug in, and we are operating at a level of excellence that I think is confusing to opposing counsel because they're used to sort of plaintiffs' cases being cost driven in a very different way. So congratulations for all of this year's success and for what I'm sure will be more in the coming year. So another question. What do we see as ClientEarth's role in the Gulf of California as complementary to Mexico-based partners? And just, I think more broadly too, Hana, if you can talk about the ways that teamwork drive our achievements in 2025. You mentioned our partners in Mexico in the Gulf of California work, and interested in just hearing a little bit more about that.
Yeah, absolutely. I think it's we really benefit from being a global organization. ClientEarth has, I believe, now 9 offices around the world. The U.S. and our Japan office are the newest additions to the ClientEarth family, and yeah, I mean, I think we really do benefit from having both the kind of jurisdiction specific legal expertise, but also understanding the political, and the policy context in those countries, right? And being able to engage with different stakeholders and build relationships that can, lead to more kind of meaningful conversations and meaningful engagements. So I think with respect to the Gulf of California, we support the work on the ground in many ways, but I do want to just highlight one, which is, as I mentioned earlier, one of the key players in constructing this LNG terminal is the financial backer named Mitsubishi UFJ Financial Group, MUFG. And they are, you know, again, a central kind of financial institution in Japan. Their support for LNG is not exclusive to the Gulf of California. Unfortunately, they've been behind a number of the LNG projects that we're seeing in the US and globally. And so we have both directly and also in coalition with other groups really been using various tools at our disposal to put pressure on this bank and to engage with financial regulators in Japan and other stakeholders to highlight how harmful their activities, their financing activities are. And so, I think we're also able to channel, what is happening on the ground to these financial stakeholders. I think one of the kind of key issues, that happens is that they are so divorced from, the impacts on the ground that they don't either realize that they're violating their own policy commitments on environmental social issues, or that they are being just deliberately kind of ignorant and ignoring these impacts because they don't have the right due diligence processes in place. They don't have the right internal controls in place. And so we're using corporate and financial laws to really remind those companies and to put pressure on those companies that they need to be cleaning up their acts, including, I think our focal point is the Gulf of California, but I think we're trying to address, their broader fossil fuel financing activities.
Great. And I will just, recognizing Hana's being a bit humble here in her background, in the Gulf of California work and specifically the LNG financing, Hana brings many years of experience in negotiating with MUFG in particular, but Japanese financial actors, even prior to coming to ClientEarth. And so it allows us to play this really important, unique role of partnering with NRDC and Dan on the ground in Mexico. So, NRDC can bring their amazing skill sets to the fore. Dan is doing the really hard, litigating against these projects, project by project, and ClientEarth can support in this commercial, corporate, financial expertise. So it's been a really strong partnership. And thank you to Hana for, bringing your expertise to bear on that. So our goal has been to keep this to 45 minutes, recognizing that it is the Tuesday before Thanksgiving, and yet we have a wonderful turnout and are so grateful for everyone to be here. So thank you for that, but we are going to stay true to our commitment. As we wrap up today's session, I'd like to thank Setareh, Hana, and Kimberly, and most importantly to all of you for joining us. We all know it's been a challenging year for the environmental movement, for a lot of things, for the environmental movement. And thanks to your support, we've been able to make exciting forward strides, and we are just excited to share that with you today, and thankful for you being here today, hearing about it, and for your ongoing support day after day, month after month. On behalf of ClientEarth, we wish you a restful, joyous holiday season. Have a wonderful Thanksgiving this week, and we look forward to seeing you in 2026. Thank you so much.